Good afternoon. We're just going to take a few seconds here while folks enter the Zoom room. We have quite a few people registered. I am Michelle Wagner, and I'm with NAMI New Hampshire, working on the first episode Psychosis Early Serious Mental Illness Initiative. Thank you for joining us for today's webinar titled, When Someone in Need is Refusing Help, Navigating the IEA Process. This presentation is being recorded. Oops, I think someone might need to mute. And you'll be able to find it on the education page of onwardnh.org. In the next couple of days, you're going to receive a follow-up email with links to both an evaluation and the recording. This is a Zoom webinar. That means your camera, folks who are watching us, and your camera and microphone are off. The Q&A is working, so please enter any comments or questions you have there. My colleague Karen Privé is with us to help field your questions. We have a great panel today to talk with us about the involuntary emergency admission process, and I'm going to have them introduce themselves. I'll start with Pierre, then Mohammed, and Kimberly. Pierre?
Hi, my name is Pierre Brazeau. I'm the father of a loved one, and I have experience working with IEA processes in the past and have been involved in a recent panel looking at future ways of online IEA processes with the state of New Hampshire.
Thank you, Pierre. Mohammed?
Hi, my name is Mohammed. I'm one of the psychiatrists at New Hampshire Hospital and an assistant professor at Dartmouth. I've been involved with inpatients and outpatients and the IEA process for the last 2.5 years. And I'm also one of the newer members of the board of directors at NAMI New Hampshire.
Yes, we're very happy to have you. Thank you, Dr. El Sayed. Kimberly.
Hi, I'm Kimberly Goldberg. I am the director of the Acute Services Program with Lakes Region Mental Health. I have worked with them for the past 8 years, all in acute services. So I am very familiar with the IEA process.
Thank you, Kimberly. And I too, like Pierre, I'm a family member, so I have been on the other side of that IEA process, trying to get one filled out and not sure how to navigate the whole very convoluted process. And we've heard that from many folks who call into our information and resource line at NAMI New Hampshire. What do we do? What are the next steps? What does this look like? So we decided, even though we've had a webinar, whoops, Mohammed, I'm just going to mute you because we're getting some feedback. We had a webinar back in June of 2022 with Judge King to talk about the judicial view of filling out that paperwork. We had a lot of folks on that call, but we know that we need a more step-by-step process, sort of soup to nuts. So that's why we're here today. And with that, I'm going to turn to you, Kimberly. Can you just give us an overview? What does this process look like? You're out in the field doing this. So what does it look like?
So the IEA process is not an easy one. I think that's a great place to start, Michelle. It can be difficult to not only fill out the actual paperwork itself, but generally when you're filling this paperwork out, that means you're dealing with a loved one who's in crisis, which can compound all of those things, so much. Because how do you manage that and try and do this very serious legal paperwork? And I think that's a really important part to bring up, is this is legal paperwork that we're dealing with, and we're dealing with the process of taking away somebody's right to be free. So it's something that that friend, family member, loved one should take very seriously, and it's one that the teams that you'll be dealing with either at the community mental health center or hospital also take very seriously. But all that being said, please remember that there are people, there are teams out there that can help you with actually completing this paperwork. You don't have to do it alone. Please, reach out to us. That is part of our jobs, to help folks who are completing this paperwork with not only understanding how to fill it out, but the reasons we can and can't fill it out, which are that's another big piece of this, is making sure that the reasons that we're trying to actually IEA somebody, or involuntary emergency admission, in case we don't know that acronym. So making sure that they know that this is a good and valid reason to be filling out that paperwork. And that's the place I always start with whoever is filling out the paperwork, is making sure that they know if the reasons that they're attempting to get this person IEA'd are valid reasons, and reasons that will uphold in a court, because this.
And can you tell us what those reasons are?
Sure. So the biggest ones that people probably may know are threats to kill oneself or take one's own life, an actual attempt to take your own life, the inability to care for yourself, and homicidal ideation is another one. There's all these reasons to have to connect back to a mental health reason. So it has to relate back to the fact that this is being caused by a mental health condition. So those are the top reasons that people end up usually being IEA'd. The reason I mention that it needs to be related to a mental health condition is one of the things that we can see on a fairly regular basis is somebody who's IEA'd for solely substance use reasons, and maybe they don't have a diagnosis of a mental health condition. And that's one of the reasons, or one of the things that we cannot actually IEA somebody for, is just due to substance use only. And that's, one of the educational pieces that we often have to discuss with family members when, they see a loved one who's struggling with their own substance use. But those first steps that we take are going over the form with folks. And it is quite a lengthy form. Thankfully, you don't have to fill the whole thing out as a petitioner. And that would be your title kind of within this paperwork. If you're completing one, you would be the petitioner. One of the things that I want to make sure people always know is making sure that you have a valid phone number where somebody can reach you, a valid email address where somebody can reach you. Thank you, Michelle. Michelle's putting up the website for where you can access the actual IEA paperwork, and all of this. So much of this can be done online now, which is a whole new process and makes it a little bit easier for folks. Not super easy, but a little bit easier, and that's something. So having that valid phone number and address are really important, because as I said earlier, this is going to be a court process. Once this goes through its initial kind of validation with the at the hospital, usually the emergency department setting, then that's when the court process happens. But as you can see here, this is the first page of the IEA. Thank you so much. So you can see right there where it says petitionee's information. So that would be the person that you're attempting to have IEA'd. And the petitioner's information would be the person who's actually filling out this information. Down at the bottom there where it says hospital and certificate information, that's information that would be completed once the patient is seen by a mental health clinician or professional in the emergency department setting. So you wouldn't need to fill that out necessarily initially, but it would need to get filled out once we've identified that this is valid information. So already right there, I think you can tell, like, this is a lot of information you're going to be putting in. So that's why I always recommend getting in contact with your local community mental health center who is very willing and able to help you fill this information out. And that can be done in a multitude of ways. So sometimes we ask people to come into our office. Sometimes we help them out through telehealth or just over the telephone. But one of the easiest ways to access help with this is utilizing the New Hampshire Rapid Response Access Point at 833-710-6477. And they can connect you to the Community Mental Health Center, who will give you a call back and help you walk through this process. So in our next part of completing this, we're looking at the petitioner statement. And Michelle, if you wouldn't mind pulling up page 2 for me. Awesome. And a lot of this stuff is pretty straightforward as far as, you know, who you are as the petitioner, that's going to be your name, and what your relationship is to that person. And then the person that you're actually attempting to have IEA'd. Now you can see about halfway down the page, we see within the past 40 days, and there's a checkbox there. And that's, you know, the checkbox that you would use if somebody had actually attempted to take their own life. You can check more than one box. The biggest thing you need to remember is you need to have the information to back up all of that info that you're identifying has been the safety concern, or what I always identify as the imminent danger, because it has to be imminent, it has to be happening in this moment. This person is going to be a danger if they don't get this help, not next week, not next month. It has to be in, you know, the very, very near future. And any information that you're including in this petition statement for whatever category you're choosing has to be within the last 40 days. So we ask that people make sure that they're not including any historical data in when they're completing the IEA petition, because it won't be valid or relevant to this particular incident. So the one of the most difficult things that I find for loved ones who are completing this paperwork is having to stick right to the facts and leave out a lot of the emotions that can be associated with such a difficult time in their relationship with the petitionee, excuse me. So, you know, because this is legal paperwork, we want to make sure that we're just sticking to the facts. We're only including the information that's relevant to how they actually attempted to hurt themselves, hurt somebody else, or how they're not taking care of themselves. You know, a lot of times family members will put in information about the person's emotional state, you know, stating things like they've been very sad, which is very relevant to maybe the clinician that might be doing an evaluation later, but not necessarily for the legal paperwork. And that's kind of a difficult area to navigate when you're trying to complete this paperwork. So if we look on the additional pages, you can see that there's areas like B here at the top. You could say within the past 40 days is threatened to inflict serious bodily injury. So that would be if somebody had actually threatened to take their own life, but hadn't actually acted on that yet. That's the box you would check for that one. And you can see as you go through, there's the multitude of options that we talked about, or that I spoke about earlier. And then when you come to page 7, you'll see that there is a signature page right there. And I like to point this out because we do get quite a few of these that come in without signatures. And we need that signature for this to be a valid form. So just a little highlight there, making sure that you remember, if you have to fill these out, to sign that statement as well. There is an option on the next page, and it looks very similar to the petition statement, to add a witness statement. So if there is anybody else who has that same information, that, or some additional information about why this person is an imminent danger risk, then we want to have them included in this information. The other thing I should mention is we like to have the person with the firsthand information fill this paperwork out as often as we can. The law does allow us to have firsthand hearsay, which is like one level away from the person who originally experienced that. So let's say a sister hears their brother make suicidal statements, but they're not able to fill out the paperwork for some reason. But the sister says that or tells all the information very clearly to the clinician, and the clinician would be able to fill out that information for you. And that would be a legal way to utilize that information without getting too far away from the actual source itself. So the nice thing is those are the only pages that you would need to fill out as either the petitioner or a witness. So you wouldn't have to do anything after that. Anything after that should stay blank until the person is actually transferred to the emergency department. And those last pages are completed by the staff at the hospital, whether that's a mental health clinician, a physician, APRN. There's an array of folks that can actually do that. And their job at that point is to make sure that all the information that's been put in the petition statement is valid, is real, is, an actual, meets the actual criteria for completing this IEA. So, I say that because sometimes we get information that doesn't meet the criteria, or we find to be invalid for some reason, whatever that may be. And we aren't always able to keep that person in the hospital if we can't validate that information, or if the information included is not valid reasons for completing an IEA. So there is always a chance that even if you filled this out perfectly and, it's all correct, that this person will remain in the hospital. They may end up going home if we don't have the criteria met. So that's why these next pages get filled out afterwards, because we have to validate all that information. Because anybody can fill out an IEA. You don't need any level of degree or training or anything like that. Anybody can fill these out. So it's really important for us on the other side to make sure that this is getting filled out in a valid way and not being completed for, nefarious reasons, I suppose. So once some of you may be asking, okay, how do I get this person to the hospital? Because they don't want to go. They don't recognize that they're having, that they're causing an imminent danger to themselves or somebody else. So in those cases, we use a form called a complaint, formerly known as a complaint and prayer. And that document has to always be associated with an IEA. You can't have it individually by itself. It has to be with an IEA. An IEA can be done and completed by itself, and you don't necessarily need a complaint, but you always need an IEA if you're going to do a complaint. And that complaint is a short, and Michelle, do you have that to pull up by any chance? A short document that needs to be notarized by a justice of the peace. And once that's completed, it's brought to the emergency or the police department with where the patient lives with the IEA paperwork, and the police will then go and get that person and bring them to the emergency department for the evaluation. So this is the complaint. As you can see, it does have some information that needs to be filled out in here, but much less than the IEA paperwork. So you would need this to make the transfer to the emergency department a legal transfer. If somebody's already in the emergency department, like I said, you don't necessarily always need this piece of paperwork, but it's good to know if you ever do need it. So the once somebody actually gets to the emergency department, as I said, they'll be evaluated by a mental health professional when they're there. And they determine if this information is all valid, all good, then the rest of the paperwork gets filled out. That's another reason why we need to make sure that we have a valid phone number for you, because we will be calling whoever the petitioner is and the witness. If it's, as long as their information is valid on this paperwork. If we can't get a hold of you, we may not be able to validate that information. So please make sure that that's a number we can absolutely reach you at. The other thing that may happen is the person may get to the emergency department and say, hey, I recognize now that I'm having a mental health concern and I need hospitalization. So that may be a time where we end up hospitalizing somebody voluntarily because they're able to consent to that and they're willing to consent to that, which is always what we would rather do, as opposed to actually having to take away that person's right to be free, like I said before. So, you know, that is also a possibility and something that we keep in mind. If we feel like that person's continues to be a danger to themselves or somebody else, or that they can't consent to a voluntary hospitalization, we may still proceed with the IEA process. So once we found that everything is valid in here and we've completed the last few pages of the IEA, all of that gets sent to New Hampshire Hospital and the court. And the court sets a court date for a hearing based on the information that's in the IEA. And that needs to be done within 72 hours. So not counting Sundays and holidays. So please keep that in mind, that if you turn this in on Friday, you may get a call or an email saying 8 a.m. Monday morning is a hearing. So please be aware of that, because if you do not attend that hearing, likely the case will be thrown out and the person will be discharged, because they have the right, just like in any other hearing, they have the right to, you know, discuss what's going on versus what's being said in the IEA. They will also be appointed a lawyer, just like they would for any other court case as well. So that's an important piece to keep in mind for any family member, that, you know, you will actually be speaking with a lawyer and in the court. Thankfully, 99% of these hearings are by phone, and the patients are usually there by telehealth. So don't necessarily need to have to drive to court or anything like that, which is great. So usually that makes for an easier process, and most people can attend that. So once that, if that IEA is upheld by the court, then we hope that that patient gets transferred to a hospital at that point. Excuse me, an inpatient hospital. and they are able to stay there for 10 days, unless there's another reason why they need to stay longer, which Dr. El Sayed will, I'm sure, talk about. And if they don't need to, or if it's not upheld, then we need to discharge that person, or we need to figure out another reason why that person needs to be IEA'd. So we can complete another IEA if that information has has already been used. We'll need new information to complete a new IEA. And that is a really summarized version of what the process looks like for completing an IEA.
That was fabulous, Kimberly. And of course, we've had loads of questions and comments come in. So Leah asks, is there a difference between an IEA and an IEH?
I am unfamiliar with the term IEH, so I apologize, but I don't know.
I am not familiar with that term either. So wish we could help, but and then BJ is saying, wouldn't it make sense to change that SUD, so substance use disorder exception, since SUD is so often a way to medicate untreated mental health, and since inhibitions that might be present without the SUD aren't there when using? There's definitely a correlation between the two. Can you speak to that a little bit?
Oh, I definitely don't disagree with you that usually there is a mental health concern when somebody is using substances or abusing substances. I don't generally see that in a vacuum by itself. That being said, substance use disorders are considered medical disorders, not necessarily mental health disorders, which may be a little confusing because they are, it designated in the DSM. I'm hoping most people know what that is, but they are technically medical conditions, which is why they're not considered under an IEA. But I do think that this is a very valid concern and a very valid point.
Thank you. Samantha says, is IEA only for adults or for youth as well?
Technically, it is for anyone. However, if somebody's under the age of 18 or they have a guardian, you can actually hospitalize somebody as a voluntary by guardian. And generally, we would utilize that for anybody under the age of 18. The exception to the rule may be if that parent or guardian doesn't understand the severity of the child's mental illness and doesn't feel that they need to be hospitalized, when a clinician, in fact, does feel like that's a valid concern.
Thank you. Megan helped us out with IEH. She says police departments often use the term IEH, involuntary emergency hospitalization. Thank you, Megan.
Thanks.
Many of us have learned something. And Ebony had said, what does the petitioner do if they report the harmful behavior, but when the person is evaluated, they say they aren't going to act on this behavior, so they're sent home, and then they be engaged in the behavior again? This becomes a frustrating process because we have to fill out a new IEA over and over.
Yeah. So sometimes when we see a pattern like that, it helps us with being able to actually end up keeping that person. A lot of times, we unfortunately are not mind readers. We can't predict the future. So sometimes it's about the way the information is presented. Sometimes it's about the way that the person, the petitionee, presents when they're in the emergency department. And, if it's something that we can't necessarily prove, because again, this is legal paperwork, we
Right.
may not be able to keep somebody, even if it's, information that seems valid in the moment.
Yeah, there's a lot of legalities involved here, for
Yeah.
sure. And what we like to tell families is keep notes, keep notes, keep track of what's going on with your loved one, date it, time it, describe it in detail. So then you have this information. You do have to fill out an IEA. Really important to have the data because you're not going to remember. You're in crisis.
Absolutely.
So,
Another
Wonderful.
recommendation I would give is, if there's Facebook messages or text messages or anything like that, keep copies of those, print
Right.
those out, bring those with you when you're filling out this paperwork. So we have that proof right in front of us, and we can see, oh, that yesterday at 5:20, they said this thing.
Right.
So,
You're building a case, and it's to protect your loved one. Yeah.
exactly.
So Megan says, I work for CMHC and we've had IEAs overturned for first level hearsay, depending on the hearing officer. So in our experience, having the person who directly witnessed heard the information, supporting imminent risk is a stronger petition.
It's always our preferred method. It's just once in a while we have reasons why we can't do that. Sometimes it's about the relationship between the petitioner and petitionee that causes us to, fill it out ourselves. Sometimes it's just that person's out of state and we can't get them here to give us that information. So we'll do it ourselves. But yes, we always want firsthand if at all possible.
And BJ says, I work for a municipality. We had a man here that our mental health agency recommended we complete an IEA for. They refused to see him because of how dangerous they believed he was, and they said they don't have the ability to serve him. What do we do in that case?
Is that the police that refused to do that?
I'm not sure who refused to see him because of how dangerous they believed he was. Yeah.
Sometimes with once somebody's in the emergency department, there would be very little reason why somebody wouldn't be seen. It may be delayed because somebody needs to be medicated for whatever reason. Maybe they're being aggressive, but eventually we would end up seeing that person. We can't, the police aren't going to cause a more dangerous situation. Like they're not necessarily going to break down somebody's door unless they know that somebody's actively trying to hurt themselves. So that may be part of the concern that's happening. It could be, this is a known person to them and they know they have firearms and they're worried about, being hurt themselves. But I can't really speak for the police departments as much.
So BJ did qualify, no, the mental health agency wouldn't see this person.
Yeah, I'm not sure about that. I can't really think of reasons, but there may be intricacies there that I'm not aware of.
Right, right. And one more, and then we're gonna, oh, Pierre, please. Go ahead.
During, in the case the health agency, maybe, but the hospitals are, so the police are bringing an individual to the hospital emergency department. They have the capability of handling that kind of individual versus the mental health agency not being equipped to see someone. That would make sense. That's where the compulsory and the IEA and using the police to transfer an individual to a secure location, a pod where they can get appropriate medication and be managed and evaluated appropriately.
Thank you, Pierre, for adding in. So we'll go back to the questions. I wanted to get on as many of them as we could because people are very engaged. So Mohammed, Dr. El Sayed, what does it look like on your end? What are you doing at New Hampshire Hospital?
Well, before I talk about what happens in New Hampshire Hospital, let me just talk about the last part of the IEA that gets filled out by the psychiatrist and the medical doctor. Can you bring the IEA back to the screen, please?
Sure.
Thank you. Thank you. So after the IEA gets filled out by the petitioner and the client goes to the emergency department, that doesn't mean that this goes to the hearing. there's still some part that needs to be filled out by the physician or the APRN in the emergency department. That includes first a physical examination, and it's just a complete physical examination to make sure that whatever the patient is experiencing is not because of a medical problem that needs to be, and the patient needs to be admitted to the medical floor. So this is just a complete physical examination. Sometimes they do some blood work, and sometimes they do urine toxicology, just to make sure that, as Kimberly said, this is not substance use is considered part of medical problems. So just to make sure that this is also not a substance use problem. After the physical examination, there comes the mental status examination. And that can be filled out by a clinician. Does not need to be a psychiatrist or an APRN, but it needs to be a clinician. So after the clinician goes and examines the patient, either in the mental health center or in the emergency department, they fill out the whole document stating how they saw the patient, and usually the examination also talks about how the patient is presenting danger. So if the patient is experiencing any suicidal thoughts or homicidal thoughts, adding this to the mental status examination would strengthen the IEA. And then going to the, so that parts need to be filled out. So that last page need to be filled out by either a psychiatrist, a BA, or an APRN. This is when we say, okay, so the psychiatrist or the clinician examine the patient, and then we think that the patient needs to go to on an IEA to that place, which we call a designated receiving facility. It just means that a facility that that has an inpatient psychiatric hospital. Most of the time, these hospitals are locked, so patients cannot go out. Most of the time, when people fill out the application, it just states New Hampshire Hospital as a standard, because this is the main state facility where patients can be here in an involuntary status. As Pierre said, well, most of the hospitals that have involuntary admissions or have can receive patients, they do have staff that can support a patient who is in danger, either to themselves or the others. So all the emergency departments have more staff that can support these patients and their needs, and also New Hampshire hospitals. So we have enough staff. So if someone becomes in danger to themselves or try to do something to themselves or to other people, we have enough staff that can support the patient at that moment and make sure that this does not happen. So once the IEA gets signed, this is when we have, from the date of signature of this page, we have 3 days until the court hearing that Kimberly talked about. After the court hearing, and the court hearing just states if there is a need or a cause, a probable cause for the patient to go to an inpatient psychiatric facility for 10 days. So all the court states is either there's a probable cause or there's no probable cause for the patient to go to the hospital. If there's a probable cause found, then the patient gets on what we call a queue. So one of the problems with the mental health system in New Hampshire is we don't have enough beds for everyone who's in the ED to get to the hospital. So this is why sometimes patients get right away. So sometimes there's no queue. The patient is the first in line. We have a bed at New Hampshire Hospital, and the patient gets transferred right away. That doesn't always happen, and let me rephrase that. That does not happen anymore. So most of the time, patients usually stay in the ED waiting for a bed to be available. Once a bed is available, the patient gets transferred to New Hampshire Hospital. We have up to 10 days to see the patient, to examine the patient, and understand what's going on. Let's say that 10 days were more than enough, and we see that all the time. Someone came into the hospital. They were in an acute, stressful situation in their life, and this is why they wanted to end their life. But right now, they stayed in the hospital. They worked with the team. They worked with the staff, and they feel better than how they were before they went to the ED. then that's it. We ask the court, we tell the court, well, there's no need to keep the patient in the hospital anymore. They can go back to their lives. And before they go back to their lives, we make sure that the patient has an appointment to see someone outside just to follow. In other times, if someone is, oh, you can take the screen off. I think that's all for the IEA. Thank you, Michelle. In other times, 10 days are not enough to work with the patient. Sometimes some patients don't want to talk to us for most of the 10 days. Sometimes patients still have symptoms and refuse to work with the staff, either working with psychiatrists like myself and starting on medications, or working with staff and talking to staff about how they feel. And this is when we think, oh, the patient needs to stay longer than 10 days. And this is when we apply for a process called a probate. A probate is a process that allows us to keep the patient in the hospital more than the designated 10 days by the law. And it can be extended to a commitment for outpatient treatment as well. Not everyone who gets on a probate hearing does get a commitment, court order to be an outpatient treatment. It just means the patient needs to stay longer in the inpatient. Sometimes this is all that they need, or some patients do require 11 days rather than 10 days. So this is how we can legally extend their presence in the hospital. And then after they leave the hospital, they still get to the appointments without any commitment, without any court orders. Do I need to talk about the? Do you need me to talk about the court orders too, or is that okay?
I think we're good.
Perfect.
That
Okay.
was terrific, and we'll see what come through for questions. We've got a lot, but Pierre, we want to loop you in here. This process, you've been through this in years past. It's a brutal process from a parent's perspective, and you've been on a committee to help improve that. Share your perspective with us, if you will.
Yeah, I think, one thing you need to be aware of, it's a learning experience. It's typically the very first time it's in a high stress scenario. There's efforts underway to make the process easier, to make it online, to provide some how to fill out the form support. And as it's been indicated, it's important that you start documenting information in advance of an IEA if you think you're headed in that direction. Sometimes it's not clear that your loved one's going to need an IEA until something drastic happens. And then you look into it and say, okay, this is the process. I think now it's easier to find the forms. It's still a challenge to find a justice of the peace. And I think, Kimberly, you said, some of your people on your staff are JPs now. That's always a challenge. Some police departments have a JP on site, and we've used that in the past. Substance use and co-occurring. Very early on, we were challenged with that. Is it a substance use issue versus a mental health issue? And we went through the process of, our son voluntarily admitting himself, and they say, well, we're still not sure because there's substance use in the background here. So it took a period of time to really understand that it was, in fact, an evolving mental health issue. And once that was documented, it was much easier in subsequent IEAs to say, yes, there is substance use occurring, but there's an underlying mental health issue at play here. And so that can be a very frustrating process. And all I can say is that, my wife and I, you have to remain committed to the process and understand it can be challenging, it can be frustrating, but you're there to advocate for your loved one. And that's the biggest key, is to continue to, stand up and say, but there's something else here. We talked about, sometimes they recant statements. And that can be challenging unless you have documentation like messages, text messages, Facebook, or as a loved one, you may know things that trigger them. And you can say, well, ask them about this situation. And oftentimes that triggers something and a loved one, and now they're willing to disclose some of their mental health issues. And it becomes more apparent that there is an underlying issue here. When you say, well, ask them what happened that night. Like, what were they thinking about when they stated helicopters were flying over the house surveilling us? And there they've been recanting, and all of a sudden they relive that experience, and they are able to share in a way what's going on in their mind. And now a mental health clinician can see and help them. So that's another way to try and, advocate for your loved one. I think the process has gotten better. I think now there's a lot of police forces that in the past we've done IEAs and they were inexperienced in executing an IEA or dealing with mental health crisis. But there's been a lot of initiatives. My wife's been involved in one of them, which is the crisis intervention training for police departments. And police departments have gotten better at getting all of their staff trained so they understand how to work with mental health patients that they didn't 10 years ago. So challenges that we had 10 years ago, hopefully people aren't experiencing that today with IEAs, but it's always situational dependent. And every person involved has to look at their own personal safety as well. So it's a challenge. And some people, some police officers, some individuals are just more adept at dealing with mental health crisis than others. And sometimes you just have to look for the right situation. It's a challenge, and it can be really frustrating as a parent and heartbreaking, because at the same time you're trying to do this and you're also dealing with your own emotional distress of what you're seeing happen to your loved one, and that can be very challenging and also cloud this how you fill these forms out, putting too much of your own personal feelings in and not sticking with the facts. And that's just because you yourself are in crisis as well, because you're seeing someone you love dealing with mental health illness that is challenging and significant in their life, and that has an impact on you as an individual as well.
Thank you, Pierre, for that perspective. It's an important one. We have a whole bunch of questions that have come in. Where does the MSE get recorded? I'm not sure what that acronym is.
That's the mental status examination.
Oh, got it. Yes, I do know what that is. Good Lord. So where does that get recorded?
It gets recorded in the IEA in one of the pages that we showed right after the physical examination.
Yeah, perfect. Mitchell asks, what types of places will accept IEAs? Is it only hospital ERs or other types of treatment centers or medical centers? And we did bring that up, DRFs, right? The designated receiving facilities. And there was the list on the form. So, yeah.
I think the designated receiving facilities are for people to be transferred from ERs, but that's different than the question of IEAs and where will a patient be taken if you execute an IEA? Who will do an IEA? That's could be a hospital that's not a designated receiving facility. Maybe Mohammed or Kimberly can expand on that.
I think it was accept IEAs. So I don't think it was, I think it was.
If we're talking about it after the court process, then it would be a designated receiving facility. Prior to that court process, it would be an emergency department. I can't think of a time when it wouldn't be an emergency department.
Got it. Sean asks, or says, on old IEA prayer complaints, there would be a place for petitionee's address so police would know where to go to pick them up. There doesn't appear to be a spot for that anymore. Any ideas, comments on that?
There is a spot on the complaint for that information, I believe. Pretty confident there is. Now I'm questioning,
They'll be
but
delivered to,
at the very top, isn't there, doesn't it?
I
have-
state that, let's,
I
let's
don't
take
have
a
one in
look
front
at
of
the,
me.
yeah, we'll take a look at the form together. How's that?
So if somebody's already in the emergency department, they wouldn't necessarily need that address.
Mm-hmm.
But if they were filling out this this part of it, then there would be I state that
Date, signature.
So, as one thing I can add as a petitioner, when you complete complaint in the IEA, oftentimes you're the one who's bringing it to the police. And they're asking you, where is this individual? And you're saying, at this moment in time, I believe he's in downtown by this area, or he's at our house right now, or because they can be in motion. And in some cases, when our son was not living at our house, he was transient. And so it's a matter of, well, where is he right now? Well, we're not sure, but these are areas that he
Yeah.
frequents.
Yep, so
So
that
there-
makes sense.
There's an interaction that often occurs that provides that additional information to the police department to execute the order.
Perfect. Thank you, Pierre. We only have 8 minutes left, a bunch of questions. So Christine asked, do the court hearings take place if they have not moved to New Hampshire Hospital?
Yes, they will. They'll take place via telehealth or by phone.
And within the 72 hours, she had added that on. Yeah, we got that. With the increasing number of patients boarding in EDs, are they holding court in ERs? We just said that. And how does this affect the 10 days if it's upheld, if there aren't any beds available?
That person will still receive treatment in the emergency department while they're there.
And I think there was a question about treatment. What does treatment actually look like? Cashlin asks, so if they are staying in the local hospital, is the patient medicated according to previous history, medications, et cetera, properly? Or do they need to wait until a bed is available at the state hospital to get that treatment?
They do start medications in the hospitals. Sometimes patients refuse them, but if there's a situation where the patient is in danger, then they can force medications.
And BJ let us know that justice of the peace lists may be available at town clerk's offices because we know this has been an issue in the past. People have gone to JPs and the JP says, I'm not comfortable doing this. Although we know from you folks that this is what they've signed on for when they agree to be a justice of the peace, correct? Okay. Let's see, guardians. Regarding guardians, what about adults with guardians through the Office of Public Guardians? Can that guardian voluntarily admit an adult against their will?
Yes.
And this is parents, parent of a youth. If a parent of a youth is unable to get the child to go voluntarily to the hospital for evaluation, would the parent follow the IEP application and complaint process to get assistance in getting the child to the emergency department?
I'm guessing they mean IEA.
Oh,
as
yeah,
opposed
yeah,
to
it was.
IEP.
Sorry. I was reading and
Um,
yeah, she corrected down below.
It could be used. It's so I don't know that I've ever seen it actually happen, but technically the answer is yes.
Okay. BJ asks, people who don't do this every day aren't as good with the documentation. Is there a template we can give to people to help them in filling that out?
So the new website that the state is using for the IEA paperwork walks you through it pretty well. And I believe that there at least was a PowerPoint presentation that helped with that as well. That was available.
James is saying, how does one manage when legal guardian does not respond to initial call from clinician nor the guardian who is on call? That becomes a sticking point.
Yeah, it becomes tough. If even if the guardian on call is not answering, then the physician can respond to the situation that's dangerous at the moment, or if there's an imminent medical emergency at the moment, but they can't take long-term decisions for the patient.
Okay. Let's see. So Catalina was saying, we now have recovery support workers in Carroll County who have become JPs for this purpose, going back to our JP question. Encourage recovery support organizations to consider this. So that's a great way to get more JPs available. And does it have to be a family member filling out the IEA? If there is a person within the community who doesn't have family but is clearly in crisis, can anyone witness to the dangerous behavior?
Anyone can complete an IEA.
Let's see, it can be very frustrating as a clinician when NHH defers a patient and there is a difference of opinion that the patient requires inpatient mental health hospitalization. Any thoughts on that? Because this happens, right? Differing opinions.
Yeah, it does happen, and I guess the stronger you make your argument and why this patient needs an IEA, this is how you can get the IEA through. And well, well, sometimes we have conflict cases here in New Hampshire Hospital that we would like to IEAs, and we have different opinions in the same case. So just try to make your argument as strong as possible.
Great, thank you for that. Kathy says, is there any effort being made to not require handcuffs behind the person's back for a person that are known to the police? That might be outside of the scope of this group. I do know.
I guess the only comment I'll make there as a parent is we've experienced both scenarios. The crisis intervention training and individuals who have experience with mental health crisis are more apt to be able to work with a patient or a potential patient, but it's a challenge, and we've seen both, and it's heartbreaking. So we have our own personal opinions on it, but it's a challenge, and all I can say is that the training is helpful for individuals involved, like police officers, in learning how to de-escalate and transfer patients safely without having to resort to, a more safety approach of handcuffs. But
Yeah.
It's up to that individual, I guess, and whether they feel safe or not, and how they're handling the patient. So it's heartbreaking, and we've seen both scenarios, and
Right.
that's all I say.
Yes, and things are improving. I do an early psychosis 50-minute workshop at all of our CIT programs that we have. So we're educating and helping, and we are at time. It's 12:59. So I just want to let folks, I want to thank our panel who was here. This was a fabulous discussion. We missed a couple of questions, but we got to most of them. So thank you so much for your expertise. And a reminder that the recording of today's discussion will be posted on the education page of onwardnh.org. You're going to receive an email in the next couple of days, which will include links for the website along with the evaluation. Once you've completed the survey, you'll automatically receive a certificate of attendance. And for questions or comments, please reach out to me, mwagner@naminh.org. We look forward to seeing you next time. Until then, take care, everybody.
Thank you.
Bye.